Peter Neenan from Stewart's, probably the leading aviation team in the UK. Peter said, not probably, it is. And indeed, one of the best that you'll find globally. He's dual qualified. I didn't realize he was, well, I suppose I did, but you qualified in Illinois, I think, because Boeing were based there. It was a good place to have a certification in the US.
Yeah.
And described, I think, as a dream attorney for anyone to have. I suppose I'll have to share that now. He's been involved in many of the leading aviation cases. He's been involved in cases from both of the 737 MAX cases. He's involved currently in the helicopter crash involving the Leicester City chair, also involved in Malaysia Airlines MH17 and MH370. For those of us at Outer Temple, it's always a privilege to invite our French and Stewarts. They're one of the reasons I stayed at Outer Temple in the sense that I came here and very quickly I got on well with them and it became a big part of my practice. So welcome, Peter. I want to introduce also John Kalantzis. He's an associate at Clifford Law, simply one of the best plaintiff law firms in the United States. Bob Clifford, who's the principal, is actually, in my view, simply the best trial lawyer I know. I both have known him for 25 years or more. Nowadays, it's common to get involved in the American Association for Justice and peer-pull. It wasn't always quite so common. I've been involved in the American Bar Association for 35 years, and I've made a lot of friends, including Bob, but it's made me a different lawyer. But those of you who don't get involved in these things, do. It's not just about the work, it's about making you a different and a better lawyer. John is a tort lawyer and an aviation lawyer. He's been very involved in the Ethiopian Airlines crash, and we're going to talk about that a little bit. And I'm so pleased also to have Eric Clifford, who's also a partner in Clifford Law Offices here today. Sarah Crowther, King's Counsel, is known to many of you. She's a key member of the travel team. She was always a brilliant lawyer. I've enjoyed seeing her grow over the last 10 years. In my view, she is one of the best conflicts lawyers I know, and her cases are testament to that. Also involved in aviation work, but I think one of the best lawyers in this field. Okay, that's enough being nice about them. Now we'll interrogate them. No, this isn't going to be an interrogation. But I thought, and I just need to check that I'm still in the screen. Vicky, I'm not walking too far. One of the things the Americans taught me was actually to walk around while you're talking. Whether it makes it easier for you, I don't know, but it makes it easier for me. And we're going to have a discussion. We're not going to have people talking. I think the way the talks have gone today, Ian, I think, has been really great. And I should add about Ian Denham. He commented that I hadn't mentioned him in my notes. They were the notes for now, but I pay a further tribute to him because I want to keep him happy. He's the head of travel. So we're going to talk about some practical points. We're going to talk a little about jurisdiction. We're going to talk about liability. We're going to talk about quantum, evidence, jury trial. And I suppose we'd like to starting off by remembering that actually this is a specialist area. There are lots of traps for the unwary, not least the limitation period. And there are lots of choices to be made along the way. So, Peter, I thought we might start with one slide that you put together. We're not going to put lots of slides up, but to frame some of it. So we could have the next slide in. And this is your indication. So non-convention-based liability, convention-based liability. What do you mean by convention-based liability?
So this slide is intended to just show really the reality of aviation accidents, that aviation accidents are rarely caused by one thing. Almost all aviation accidents are caused by a multitude of factors, and it's important to understand what the causes were, who the potential parties are. The split that we've got here between convention-based liability and non-convention-based liability refers to the Montreal Convention 1999. I should say at this point that in practical reality, I mean, Montreal Convention applies to international carriage by air transport undertakings. But actually, I did an analysis a few years back looking at domestic flights and accidents around the world and international flights around the world where you had more than 10 deaths. And in fact, only about 25% of those accidents fall under the Montreal Convention regime. The vast majority don't even fall under that regime. But more generally, what we're talking about here is the liability of the airline and the airline or the pilots and that operation. That's one side of the action, but the other side is then understanding the broader potential causes. So that could be a manufacturer like Boeing or others. It could be subcomponents within that system. You might have air traffic control, maintenance. I mentioned down here about owners, lessors, managers. ABN 67, BC, financiers. Whether there's a negligent entrustment argument you might have against those guys, or even an employer, and some of that can be framed within the concept of the EU blacklist, where you have dangerous operations that somebody ought to know about. So there's lots of, I guess the big point is that there's lots of potential defendants and there's lots of potential claims, and it's really important to understand all of those claims, all of the jurisdictions, all of the limitation periods that others have spoken about today, in order to recognize what you need to do and where you need to do it.
Okay, so John, when you get an air crash, what's the first steps you're going to take if you have a client who's been involved in an air crash and you're looking to pursue it? What are you going to do by way of investigation?
Well, you generally look for any kind of investigative reports that are out there. For instance, in the Max case, it became clear relatively quickly that there were a lot of similarities with a prior crash, the Lion Air JT610, which occurred roughly 5 months prior to the crash in Ethiopia. This is the Boeing 737 Max, for those who don't know, which is a very new plane. They were the one that crashed for Ethiopian Airlines, was purchased 5 months before. So seeing the similarities in the two crashes, it kind of points you to the direction of there's something wrong with the manufacture of the plane. You're also looking for, as Peter said, any type of pilot error that might have occurred, any type of maintenance issues. So generally, you try to get whatever information you can from the investigative reports.
And as I read some of the materials on 737 Max, I may be wrong because I've read materials and not done the case. To an extent, Boeing were rushing to get a plane out to match one of Airbus's, is that right?
Correct. So the Airbus was a more fuel efficient plane, which led to more sales from the airlines, because obviously one of their largest costs is fuel. Boeing realized that they were at risk of losing some major customers, so they redesigned. Initially, what they wanted to do was build a whole new plane. The cost of that was much prohibitive, plus the time that would have taken. They decided to redesign the Max, which, I don't know. I believe this is probably a saying that originated here in England, but haste makes waste. And they cut some corners, and there were some mistakes made,
Which proved to be catastrophic in both crashes.
Correct. And the tragedy of it all is that after the first crash, they knew that they had a defective product. They knew that changes had to be made and that this plane should not be flying until there were corrections to the software that was running the plane. They chose not to do so. It was a business decision. They put profits over people.
Okay, so coming back to Peter, I'm Sarah. So when you are instructed in a case, one of the first things you're going to look is it a convention case? Is that right?
Yes, certainly. We'll look to whether it's a convention case, look at what the ticketing arrangements are for any of the passengers on board or any of those that have contacted us, because that will provide different jurisdictions so we can understand, where they might have their claim. But then secondarily, we'll need to understand the broader aspects of that. And in part, that's to understand, other parties where we might be able to sue, other jurisdictions, applicable law, damages. But it's also because, when you have these aviation accidents, there's an investigation that's immediately meant, John comments about the looking at those investigation reports. Those investigations, the families aren't party to them. And so they don't, in most cases, they don't know what happened. There might be in some jurisdictions a preliminary statement of facts, which helps a bit, but it's written in a technical language, which is quite difficult for them to understand. So one of the other reasons why we look very early about the causes is to actually help them understand what happened. And that's really key for families.
Because it's commonplace in disasters generally that people one, want to know what happened. Two, they want to make sure it doesn't happen again.
Yeah.
And thirdly, they naturally want to look at what routes to compensation there are. Those are three of the things that you juggle with, I suppose.
Correct.
Okay. And I can ask Sarah this actually. How specialist is this jurisdiction, Sarah? You and I sometimes come across cases where people really kept a case that they perhaps shouldn't have kept. Is that something that you think is commonplace?
Oh crikey, you put me on the spot there, Gerard. I think it is a dangerous area to dabble in because you don't know what you don't know, and there are a lot of traps for the unwary, particularly around, I mean, obviously there's the technical aspect of aviation, which is its own separate thing, but when you get into the framework of looking at jurisdiction and applicable law and the rules on who has jurisdiction and where and how that might work, there's a lot of space for that to go catastrophically wrong in the litigation, and a lot of the time there aren't any clear-cut right answers either, because the clients might have potential different options in different jurisdictions, and you need to do quite a lot of work to find out actually what is the best option overall, because limitation periods will differ, damages assessments will differ, liability regimes will differ, thresholds and standards of duty of care will differ as well, and they don't all necessarily point in the same direction. So there's quite a lot of work to be done there if you've got 3 or 4 possible applicable laws before you can even say to the client, well, actually we think the best option is this one, and that might mean then serving out, which brings with it its own issues as well. So yeah, I mean, that's a long way of kind of saying you don't want to be doing this if you're not completely confident that you know all the technical sides of it. And especially
Peter, is there a difference between how you approach a convention case and a non-convention case? Is there any difference in the initial investigations you want to take?
Well, I mean, I don't know if I would ever characterize something as a pure convention case. I mean, sometimes there aren't any other parties, so in those circumstances, then yes, there's a difference in the investigations. You might not need to go any further. Obviously, the purpose of the Montreal Conventions, it provides a strict liability regime and a reverse burden of proof above 128,000 SDR. So you kind of don't need to go much further in that case. You can bring those proceedings quite quickly and you can resolve those cases relatively quickly. But you need to understand if there is another case before you can have confidence in that process. So you need to understand if there is another jurisdiction. That might not mean you don't bring the Montreal Convention case or you don't resolve that dispute, but it might mean that you change the way that you finish the case. So, whenever you're negotiating with defendant lawyers acting for insurers and Lloyd's of London, they will invariably ask for a worldwide release. Mm-hmm. So you'll be, negotiating with these the lawyers for the airline, and they'll want every single party released from any potential claim in the future. Now, of course, if there is another claim, let's say against a manufacturer, then you might not want to release that part of the claim. So instead, you might resolve the claim under the Montreal Convention, but on a partial release basis, to give yourself the freedom to then pursue other parties.
And are there contribution proceedings sometimes behind these between the airline and manufacturers and maintenance people and so on?
Yeah, I mean, absolutely. There's oftentimes not necessarily full proceedings, but certainly a contribution and agreement between the parties. We see that a lot. And I think ordinarily, a lot of the time, you'll find that the liability is driven through the airline, with risks of other parties feeding into that end result. And I think, the ET302 case is one of the only cases I can remember where no one really bothered with the airline, just went straight after the manufacturer because it was such a unique set of facts. Yeah.
Obvious.
Yeah.
Change it. Okay. And John, you may have a good claim against someone that's obviously good, but would you still want to investigate it? I can think that in England and Wales, if I was opening a case to a judge, not because I can claim exemplary as opportunity, it's very rare to be able to do that, but I want a judge to know how this came about and how it was that this disaster happened. Is that something that you look at when you get any case, convention or not?
Yes, of course. And a big part of it is Peter was saying, I mean, your clients are dealing with a horrific tragedy, and they want answers. So whether that'll lead you to punitives or whatever kind of case you may have, you're going to investigate to the full extent that you can. I know with the ET-302 crash, part of the difficulty was Ethiopian Airlines is also owned by the Ethiopian government, who is also in charge of the investigation. So there was a large delay in the final report coming out, coincidentally.
Okay. So let's talk about how we deal with jurisdiction. John, you would like to bring claims in the United States, and preferably, certainly until they move their headquarters, you'd want to bring it in Illinois against Boeing, wouldn't it?
Correct. I believe that it's the United States has some of the best damages law in the world. And within that, Illinois has probably, out of the 50 states, we're probably in the top 2 in terms of the elements of damages that you could seek and the amounts that juries are willing to award.
The modest amount of learning on this tells me that economic losses, we can get good economic losses in England and Wales. But it's the pain and suffering, it's the loss of consortium, it's the jury award for what happened that's different, isn't it?
Correct. And that's where, some of it is art versus science. Economics is generally science. You have hard numbers that you can base it on. Now, when you have the non-economic damages, which is the grief and sorrow of the surviving family members, the loss of society, which would be the loss of the comfort, love, guidance from the family member that they've lost, along with the survival action, which is what the deceased went through prior to death, the terror and emotional distress that they felt. Those all add up, and it's difficult to put a value on that. It's, how do you value a human life? So you have to work to kind of illustrate the difficulties going forward for the surviving family members.
And I think I explained this morning that wrongful death as such in England and Wales attracts very little by way of a damages award for the death itself, less than 15,000. The economic loss is rather better placed, but that's a real disinclination, I think, to anyone trying to bring a wrongful death claim arising out of a disaster in England and Wales. If there's a choice of jurisdiction, that's part of it, isn't it, Peter?
Yeah, definitely. I mean, when you're looking at jurisdiction, I would obviously hardly agree with John that the US is where you want to be, and if you have a claim where you don't have a financial dependency, the UK is not where you want to be. But there are other nuances to it. If you can't make it to the US, then you can make it to somewhere like Brazil or Italy. That might be a good second best. And I think that if you can make it to the US, but you can't make it somewhere in Illinois, it may not actually be as good as you think, because there are certainly, in my experience, states in the US where you get kind of conservative jury awards where they are just not prepared to award the kind of damages that you would expect, and you would even probably manage to succeed just on your economic losses in the UK. So there's, you just have to.
So it's not straightforward.
It's not straightforward, no.
Okay. So typically, what are the possibilities for jurisdiction? Let me ask John first, and then perhaps you, Peter. What are the possibilities for jurisdiction in an accident that happens outside the US, but in an American-built plane? What are the possibilities you would think of? I mean, you'd always think of America, isn't it?
Correct. Also, the location of the crash. When I can speak to choice of law, still some Sarah's thunder here, but part of the factors that are weighed is the domicile of the victim and the defendants, place of the crash, and also any other kind of where the wrongdoing occurred. So those are just some of the factors that are balanced for us, and where the relationship between the victim and the wrongdoing, when the defendant is centered, where they entered into the contract.
And Sarah, I know that some of the cases you've been involved in, aviation and non-aviation, that there is a choice. On occasions, you can go and look where a parent company is based and things like that. Do you have any experience in that?
Absolutely. So from the jurisdictional perspective, I mean, if you can identify a parent company and evidence that there is sufficient control by that parent over the relevant activities as a subsidiary, then that can be a way into jurisdiction. By all means, it can have an influence on choice of law as well. I mean, obviously, our rules are taken from the European scheme in the Rome 1 and Rome 2 regulations, so they tend to be less flexible than the kind of scheme that John is describing. And from a tort perspective, so if you're kind of outside Montreal Convention, you're looking at tort claims, then obviously there's a very strong emphasis in the Rome 2 regulation on the place of the tort, which obviously in a wrongful death claim is always going to be where the accident happened. So there's less flexibility, I think, by the sounds of things anyway, in the European scheme that we've now adopted for choice of law. But certainly in terms of jurisdiction, you can definitely be looking at parent companies. The challenge there quite often then is to identify through disclosure or other means how it is that you're going to evidence the control that the parent company was actually exercising over the subsidiary, because there's an information imbalance immediately. You're on the outside of that. They organise. Although it's amazing what people do put out there on the internet if you care to look.
Okay. And Peter, in the course of your work at Stewart's and with Sarah Stewart and your team and so on, one thing you've got to get used to is co-counselling, isn't it? And getting the right team and working with them alongside other plaintiff teams, I suppose, on occasion. So you've had to learn to collaborate and cooperate in those. Is that right?
Yeah, definitely. We often have multiple co-counsel teams working on the same accident. So there might be a US co-counsel team where we've got a claim in the US or something like that. But also, we often co-counsel in jurisdictions where we can bring proceedings against the airline or against another party, particularly in circumstances where the US claim might be weaker and risky. So one of the things that we find quite a lot is because it's quite a specialist area of law. We've worked in some jurisdictions, for example, in Tanzania, where you have what is effectively historical English law, but no real cases that have pushed that forwards since in the independence of Tanzania, but the principles are the same. So it's really interesting working with those co-counsel to try and bring cases that we would advance in England within Tanzanian courts, and working together with them to try and use kind of the English adoption of principles through the historic case law in Tanzania in order to get the right result for your clients. And we've had some success with that. And it's a nice kind of additional way of getting compensation, again, on that partial release basis alongside any claim that you might have in a more favourable jurisdiction. And
you reminded me when we first started that we had two titles. We were going to do aviation law in the UK and aviation law in the US, and you said, that's not the case. And of course, if I thought about it for a moment, I would have known this, but this is a real global area of law, isn't it? It's a universal convention, or almost universal, with over 130 signatories. And do people on occasions try and get a uniform interpretation on it? Uniformity under the Montreal Convention is one of the principles on which it's based, and that is certainly how it's meant to be approached around the world. I don't personally believe that that's true. The US is particularly bad at it. No, it's just that they know what uniformity looks like. So, in theory, you should have interpretation in a uniform manner. I mean, when we get into talking about some of the cases, I think there are good examples of how you get this diversification of how that looks, it's challenging. I mean, one example actually, which I don't think we were planning to talk about, but it's an interesting case, is a decision following a crash of UTA 141 that crashed in Guinea in 2004, I think, and there was 141 people that lost their lives, and it was a case governed by one of the older conventions, the Warsaw Convention 1929, and the families were compensated
8,300 SDR, which is about £10,000 each. It was a tiny amount of money, but some of these families were from Lebanon, and they brought proceedings in Lebanon under criminal law, and they were effectively kind of party civil type claimants within that process. And the court said that was okay, and they could bring those proceedings, and they could be compensated on top, and they all got about $300,000 on top of that. Now, in the Montreal Convention, there is a very strict rules about the preemption claims, and in other jurisdictions that just would not happen. It would not happen, but there you are. You've got a decision from Lebanon where they didn't pay any attention to those other decisions in the UK and the US.
So when you're starting out, you've got to look at the convention. You've got to look at liability generally.
Mhm.
You've got to look at choice of jurisdiction. You've got to look at choice of law.
Yeah.
I think you've got to look at enforcement as well. I know it sounds like you're looking down the wrong end of the telescope, but in the end, if you've got a judgment and you want to actually secure the money from that, then it's got to be an enforceable order. And those enforcement issues play back into foreign non-convenience as well, because there's no point issuing a writ over the road there if actually the place where you want to serve that claim form is a jurisdiction that's never going to recognise a judgment of the High Court anyway. It's an absolute waste of time, because you'll have to go and relitigate the whole matter all over again. So I think that is quite often something that we look at quite hard in terms of giving clients practical advice about risk, which is something obviously that they need to factor in. There's one thing to say, well, you've got this chance of getting an amazing award of whatever, but it might not be enforceable. That puts a very different complexion on it.
Okay, so I'm very conscious I could spend a full afternoon on this.
Sorry, Jerry.
Easily. I've only got one slide of it. We're not going to go through lots more slides. We are going to show you some demonstrative evidence later, kinds that is more often used in America than here. But we get over these initial things. So what will typically happen? John, can we talk about ET 302? And I know that you had some passages on that as well, Peter. That is a matter where some cases are settled, some cases are going to trial on quantum, but I think liability was dealt with comparatively early for at least almost all the passengers. Is that right?
Yes. So what happened, and this was kind of unique to this crash, is that Boeing admitted liability, which is not unique. They generally admit liability, and as much as is for them, as difficult as it is for them to say sorry, and they want some credit to say, well, we're admitting our wrongdoing. A strategic reason for that may be that they don't want their wrong evidence and their acts of wrongdoing to come into play in the trial, especially with the jury, which is, I understand is unique to American system of justice. Basically, they want to avoid angering and upsetting the jurors. So they want to prevent us from bringing in any evidence of their wrongdoing, such as knowing that you have an issue with the software and not fixing it, and believing that you could fix it prior to a crash. So in our case, they stipulated to liability, and they also stipulated to all damages being determined by Illinois law. In order to get to that stipulation, after months of negotiation by Bob and some of the other members of the plaintiffs' executive committee, we had to give up a claim for punitives, which are generally used to punish the wrongdoing.
How easy would it have been to get punitives, or we would say exemplary damages in Illinois?
In Illinois, it would have been difficult because in wrongful death at the time of the crash, punitives were generally not available. They were not available. The law has since been changed because of the illogical reasoning that it's, in terms of punitive damages, it's better to kill someone than to maim them, because punitives are available for non-wrongful death torts. But there were some other, arguments to be made depending on domicile of the plaintiffs, other co-defendants' domicile, that punitives could have been in play. But I believe that Boeing wanted the certainty of knowing that there will be no punitives.
Do any issues arise when they've admitted liability about how you go about proving quantum, even if there isn't punitive damages available, would you want to bring in information about how it happened, what happened on the plane, and so on?
We would love to bring that in. So part of the survival action is, again, like I said, what happened to the passengers prior to being killed in the crash. We can bring in movements of the plane, effects of G forces, biomechanics, to give the jury an idea of what these passengers experienced. We cannot bring in anything about liability. So anything in terms of the wrongdoing. We are allowed to say that, it was a preventable crash, but we are not allowed to say the specific aspects of preventability.
What it was to lead to this defective system being put on this aircraft that
Correct.
made it impossible to control for pilots, as far as I can see.
Correct.
In certain circumstances.
Correct. And exactly. And one of the issues is that Boeing never alerted the pilots to this software system being on the plane. And once after the first crash, they didn't really give them enough information to correct any kind of malfunction.
Okay. And Peter, you were involved in this as well. I think you've settled some cases. Is that right?
Yeah, exactly. After the admission of liability, we settled our cases. But I mean, one of the interesting things about this is actually the effect of the ET302 litigation on the Lion Air litigation, because the Lion Air case was a pure domestic case. You had local Indonesian on board on an Indonesian flight. You have this system problem, and there is a potential case in the US, but it's really exposed to foreign non-convenience risks. And it probably, in the absence of ET302, would have been dismissed for FNC. And it was really only because ET302 came along, which turned this into an entirely different issue to look at. And the fact that there was enormous diversity within the jurisdictions of the residents of people involved in ET302, that it gave strength to the Lion Air case to remain in the US and resolve it on similar levels.
Okay, well, that's obviously good. I mean, I confess that certainly for 25 years, as long as I've been doing cross-border work, I thought that American courts in particular are very ready to use FNC to protect American corporations. That may sound a little bit jaundiced, but of course, if you had a defective metal hip in the States, you're probably going to get recovery. You might get recovery in Wales if you'd accepted a scheme that they put together. So the hip litigation here was a disaster for plaintiffs and things like that. Equally, I represented, we'll talk about it very much, but I represented many people in the Grenfell Tower disaster, and we saw that, and we got thrown out on forum. And a rather simple approach that American companies want to sell their products around the world. They should be very happy at being sued in their home state, but I've not turned that into jurisprudence anywhere so far. But so in choice of forum, not in every case, but America will be a convenient forum. You've got the right state and the right approach, and you can work with the co-counselor.
Yeah, we haven't had a situation where we haven't been able to work with a co-counsel yet.
No, I don't think that at all. But joking apart, you need a good network of people to co-counsel with that.
Yes, you do. Yeah, and I think what we are looking at, obviously, the US is subject to what we said about the particular states. The US is the kind of number one jurisdiction that you'd like to go to. But one of the things that we have to look at very carefully is whether we have the sufficient diversity in the claim that we will be able to overcome that foreign non-convenience challenge. Because I completely agree with everything you say about the inappropriateness of it, but it is a reality. And what we don't want to do is to take cases to the US that don't have the right facts to be able to overcome that foreign non-convenience challenge, because otherwise you're just creating bad law that you're going to struggle with later. So we have to be really careful about which cases we actually go there.
It'll make it unhelpful for future cases.
Yeah.
Okay, so let's keep an eye on the time. I think people have been really interested in some of the trial practice in the US, and I'm going to cover some underground. So, John, how do we start in the US? Do we start with a complaint?
We do. We start with the filing of a complaint. And in Illinois, it's a fact pleading complaint. So you have to plead all your facts. From there, obviously the defendant gets to answer, leads to discovery. Discovery can be written and oral, where you're allowed to submit certain questions and requests for documents. And then oral discovery is taking depositions, which I know is probably rare in most of the world, but depositions, which is kind of when you said this is not interrogation, that's the first line I use when preparing our foreign clients. Like, this is not interrogation. This is not a test. but it's kind of like a very long, unpleasant job interview. They have a chance to ask you pretty much any question they want within bounds in order to determine, what information you know. And in our case, they're asking our clients for damages.
And as you say, we don't have depositions typically in the United Kingdom. I could genuinely think of some instances in which depositions, or at least some evidence before trial, might work, but that's again a completely different topic, so I'll restrain myself. But you get involved in this process as well, Peter. You have to get your clients ready for deposition and involve themselves in taking the depositions.
Yeah. See, I don't have the same level of experience as John or others from his firm, but through the US bar qualification, I appear pro hac vice in cases in the US and cases in Illinois where I don't need to be pro hac, but take those depositions, and it is a very different process. It's quite enjoyable, I think, for English listeners to be involved in that process. But it's
For the attorneys.
yeah.
Well, I mean, some US lawyers I know can't believe we don't do depositions. How are you going to plan your cross-examination? To which the answer is, we've got witness statements. We can do quite well with those. I appreciate it's very expensive, but equally, what's at stake is a large sum of money in these cases, typically, isn't it? So you had one consolidated complaint, I think, in the end, is that right?
Yes. So, and there were over, I believe, 150 complaints filed. And because it was all the same crash, all of the common discovery in terms of the liability evidence, all of the plaintiff firms were consolidated into one action. And we were, like I said, I alluded to earlier, there's a plaintiff's executive committee, which kind of coordinating amongst all the different plaintiff firms. But you still are responsible, each individual firm, for developing your individual damages, because obviously it's different for each family, each case.
And some settle, some don't. You've got some cases listed, I think, for trial in November.
We do, and correct. Some settle, some don't. This is our third trial date of this year. The original trial date was in March. There were 8 cases set for trial. The judge has come up with a system that he's very proud of called cut and choose. So out of all the prospective cases, we chose 50 cases, and then Boeing got to choose 8 cases for trial. 2 cases will be tried at the same time, and there's 3 backup cases behind each in case the trial cases settle. Sounds a little confusing, but all those cases settled about 2 weeks before trial, I'd say. So then we had another trial in June, same situation, 8 different cases. All of those cases settled. Those were about a week before trial, with the last one the weekend before trial. We now have 6 cases set for November. Those are in the process of negotiation. Depends who you listen to. Some more experienced attorneys in aviation who have been doing this for many, many years, much longer than I have, believe that all of them will settle and there'll be no trials.
But just as in the,
But it depends.
just in the UK, defendants, insurers need to understand you will go to trial if necessary.
Correct.
A concept that's familiar to many people in this room.
Yes, I mean, you have to be able to go to trial if necessary, and I discussed depositions. So some of the depositions we took, we traveled to Kenya because there was a lot of Kenyans on the plane, and we set up basically a mini TV recording studio to videotape the depositions. Now, you could say, in today's age, you could just do it over Zoom, and everyone's used to Zoom, but we knew that the quality of Zoom can be on or off, including the audio. So if this was a video, so the reason we took these partly was for Boeing to examine our clients, but also we can't bring all the Kenyans to the US with visa issues, travel issues, etc. So we knew that we wanted to record them in a high quality video. So if the trial was to occur, we could just play the recording and it'll be something that'll come across much better than a recording of a Zoom call.
And whether judge or jury, professionalism in the presentation of your case, it very much counts on that, amongst other things, I would guess.
Yes. Oh, yes.
Okay. Sarah and I were involved in a several cases in India, and this was before Zoom. We were going to spend quite a lot of money, not quite the steps that you were taking, in order to make sure they were taken. Stuart's case, almost naturally. Okay, so, and we get a jury, not a judge.
And we get a jury. So it's a little different. Again, that's one of the unique aspects of the American legal system. The jury, as I'm sure you can probably guess, you need to kind of keep their attention. And part of that is involved with more use of demonstratives, the language that you'll use, the particular vocabulary used. There's, a cottage industry, which is not really a cottage industry, probably more of a regular industry of jury consultants, mock juries where you try a case in front of a jury, and you try out different elements of your case. You try out different theories of liability, different language to use, different ways to present evidence. It's a completely different ballgame.
At least one Chicago I can think of. I've turned a moving premises quite a long time ago and said, well, where are you going to put your courtroom? Because they have a courtroom there ready for mock trials. And actually, people laugh at me when I suggest this, but why wouldn't you? In the sense to rehearse your arguments, on a couple of occasions where people have been doing appeals, they've asked me if I'll go and sit and listen to their arguments to see how they look in reality. We're learning a bit about that, Sarah. I'm not sure we've got there yet, have we?
No, well, we did do a bit of mock argument, didn't we, before the Supreme Court in Cox and Ergo? I think you were
We
one
did,
about.
you made the Supreme Court justice. It's the only world in which it's happened.
I mean, I think we are a bit behind. I mean, there are steps I think that are happening in England and Wales now, which are more along the lines of people kind of really thinking about how they're going to present their case at trial. I know that there's quite a lot of witness work goes on now in terms of getting witnesses not coached, obviously, but just prepared for the experience of being in the witness box. And I there are barristers who have a sideline in kind of cross-examining witnesses to prepare them, particularly big city corporations who are worried about senior witnesses. Yeah, they won't be asked about anything in the case, but they kind of get a hold over the coals. Because I think for someone like that, it can be quite a challenging experience. If you're someone who's used in your day-to-day job of not really being kind of challenged in that forensic way, you don't know how you're actually going to react. As some of the witnesses obviously do react well, but others that I think they find it quite a challenging experience. So I know that happens increasingly for witnesses, but no, we don't really think about how we're going to keep the judge awake in the same way, do we?
Do you guys judges fall asleep in the way they sometimes do in England and Wales?
Yes, some of the more experienced judges.
More experienced, I like it. So, Peter, you bring claims in a number of jurisdictions, but you're very used to bringing claims in the US and very used to bringing significant aviation claims in the UK. So you're well used to juries, and in general, I think most plaintiff lawyers will think that juries will probably be a good idea. Do you ever think there are cases where you might want to present a case in front of a judge and so on? In which case, what sort of case? I'm not asking you to identify specific ones, but where might you want to do that?
So, John explained the various non-pecuniary heads of loss that you can recover in the US, and that gives you a huge advantage if you're in the US as the kind of starting position of how many damages you're going to recover. But in cases where you have really significant financial losses, and I mean really high earning individuals, you do potentially come up against a problem, because ultimately when you're presenting a case to a jury, you're dealing with humans, you're dealing with an emotional response to a case, and you're dealing with numbers that they feel are fair and compensatory to an individual. If you have, for example, an extremely high earning family who are very well off, you could come up against a jury which doesn't feel they really need that much money. You could feel that you could come up with a financial loss which is enormous, but the numbers make them feel uncomfortable and they're just not prepared to order that. Whereas in England with a judge, if the numbers are there and the evidence is there, you ought to get it.
The grief may be universal, but the economic impact will depend on what they were earning at the time, which might appear to a jury to be somewhat unfair.
Yeah.
That's one of the worries that one would have, I suppose. How do you prove economic losses in the States or in Illinois, John? Do you use economists for loss of earnings and plotting the future in some?
We do, and in Illinois in particular, it's not limited to what they were earning at the time of their death, because our economic damages are based on earning capacity. So what they could potentially have earned, I guess in the best case scenario. So to illustrate, one of the cases set for trial this November was a woman who was in her early 30s, married, a young child, She was a flight attendant on Ethiopian Airlines. She had gone to university and she had a law degree. She had started working as an attorney in Ethiopia. Due to some issues with certain practices in Ethiopia that she did not ethically agree with, she became a flight attendant.
It's loss of earning capacity.
So it's loss of earning capacity.
We would do that as well. I'm not sure we do it as scientifically sometimes as we could do. We, as I've said, actually, in terms of economic losses, I think England and Wales do pretty well, actually. And in terms of structured settlements, we're probably better than the US in terms of yours being top down, ours are bottom up. And again, we're not talking about car crashes, but a lot of my American friends are always surprised at how much I can recover for a road traffic accident. And the reason for that is that damages are unlimited. The indemnity the insurer has to offer is unlimited, which is very helpful in my line of work, actually. Okay, I'm looking at the time. I want to show some demonstrative evidence first, but I just wanted to talk about something that you and I spoke about. And I've become very familiar, particularly in recent years, with the impact of grief on people.
Yes.
And we generally meet with psychiatrists to determine what impact that may have had, or sometimes psychologists. Have you been trying to adopt any different approach in the US?
We have. We have been consulted with thanatologists who are basically grief experts who specialize in the grief and sorrow surviving family members feel when someone is killed in a sudden and traumatic way, i.e. an airplane crash, car crash, any kind of thing. So basically where there's a violent death that occurs overnight, especially if it was a younger individual, and the effects of that grief that will reverberate throughout the years, not only on days that you would think like the anniversary of their death and any kind of their birthdays when people generally remember those that we've lost, but also other kinds of situations like future graduations, future weddings, holidays. I mean, this is not something that's, I don't, in the US, I know there's the myth of, the 7 stages of grief, which is not true. This is something that's going to affect these people for the rest of their lives. It not only affects them, but also affects the relationships within the family. So it's a very complex area that is not as straightforward as it seems. Unfortunately, some judges don't agree with that. They are of the philosophy that, well, grief is grief, and it's just within the province of any juror to understand grief. What's the difference of if I lose my grandmother when she's 90 and in the hospital, as opposed to, losing my younger son overnight in an airplane crash.
My guess was going to be that some judges are happy with it and some aren't.
Correct. And unfortunately, our judge is not happy with it. He is of the latter persuasion that grief is grief, and you don't need an expert to explain it to people or to give it the sheen of something that is not.
And Peter, I don't know whether you have any familiarity with that, but what certainly in England and Wales we have familiarity with is that moral damages in European countries do better at replicating the grief and the loss of someone close. I think of Italy and Greece in particular. Peter, your experience is the same, I suspect.
Absolutely, yeah. I don't think there's many places as poor as England at doing that, to be honest.
And Sarah, that's something you're very familiar with as well.
Absolutely. Although I have to be honest, it never crossed my mind that you might be able to get an expert witness to talk about the grief. So I'm learning there. But I've dealt with cases that the Italian law example that you give where, one does have to present the evidence of the specific loss and the impact that that's had on the individual. From the kind of Anglo-Saxon perspective, that feels a strange thing to have to do.
I want to just take a couple more questions on a couple more topics on the convention, and then I want to look at some of the demonstrative evidence. Peter, if someone's simply psychiatrically injured in an air disaster or an event on an aircraft that's covered by the convention, will you be able to cover for simple psychiatric loss, psychiatric damage, and psychological damage?
Maybe. So there's
I didn't warn it.
so the relevant case, I guess, here, there's two kind of cases that have moved the area of law forwards here. One is Doe and Etihad, it was a US case, and the other is BT Loudmotion, which was the CJAU. And what they are, so to try and summarize those two cases very quickly, Doe and Etihad, what you had was, actually, I should take a step back. The traditional position.
While you do that, I'll see if we can get the slide up that deals with that.
Yeah.
We may not be able to. You carry on. There we are.
So Doe and Etihad was a pricked finger on the left-hand side, and BT Loudmotion was an exploding engine and the reaction to those. So historically, the position under the Montreal Convention has been that you can only recover damages for psychiatric injury where that flows from a physical injury, and that's been the position for a long time. There was a suggestion in Morris and KLM that if you could really evidence that kind of changes to the structure of the brain, then you could maybe kind of shoehorn psychological injury in that way, but it hadn't really got any further.
Easier said than done.
Easier said than done. Doe and Etihad then came out in the US, and that case, essentially, the facts were that a lady put her hand down the back of the seat, and there was a needle in there. She pricked her finger, and then suffered a lot of psychological trauma off the back of that. And the court essentially took a kind of textual analysis of the Montreal Convention and said, all you need actually is just the tiny slightest bit of physical injury, and that opens the floodgates for anything that follows. BT Loudmotion then went much further, and the CJAU decision on it is, it's like most CJAU decisions. There's not much to it, but if you actually look at we haven't got any judges here. But when you look at the Attorney General's opinion behind it, you can start to see what the basis for that is, and particularly then if you go back to the travel paratoire of the Montreal Convention and understand it, and ultimately to kind of cut a long story short, what happened in the conference for the Montreal Convention is there was this whole big debate about whether or not you should have mental injuries or not. They were considering changing the language to include that, and then they ultimately bottled it, but put the language back to the wording that you have here, bodily injury, and just put in this clause within the minutes that you can see here. And they basically said, we're just going to leave it to state if you can recover this, then you should. But there's a lot of talk within the conference minutes as well about the importance of understanding that you shouldn't just get damages for any mental injuries. They have to be of a kind of sufficient gravity and seriousness. There should be a threshold. And that is also brought into BT Loudmotion. You have to hit that threshold.
Is that banding in England now?
No, but it's this same goes back to this point you asked about earlier, uniformity in application of the Montreal Convention. Any judge in England ought to be considering, and will consider, Doe and Etihad will consider BT Loudmotion. They're not binding on them, but they're persuasive.
And as long as we put a plaintiffs, we'll say they're persuasive ones, Sarah.
I say that there's, you've got to have a good reason to depart from them, right?
Okay, so we could spend a long time talking about this. I hope it's been useful drawing things out in this way. But I wanted to show you an animation. It's an animation that I think perhaps predates your time at Clifford Law.
It does.
I've seen it for a while. I think it's quite often. I've seen it, I first saw it a long time ago. I think it's a great demonstration of what you can put together. And then we'll just have a few minutes about whether you'd be able to use it and the restrictions on using it, and whether you get it here in England, which is probably unlikely. But I think it shows that American trial lawyers are ahead of us in managing to get information over. We pick a lot of information up visually rather than being spoken at. And that's why animations in PowerPoint presentations are a good idea and so on.
Yes, and a very smart man that I happen to work for has said, if a picture is worth 1,000 words, then a video's worth how many?
I've seen several. One of them condenses a really complex engineering problem into 2 minutes of video, and you can see immediately how something happened. Not an aviation accident, but now can we go to the comment? And I want to thank Vicky for doing all this. So this was a crash, I think, at what I might fairly call a provincial airport. When it happened, the Clifford Law firm got an injunction to shut down the airport. hired an exemplar aircraft and flew it in. And then proceeded, I think I'm right, in putting an animation together. And what had happened was that instead of going down the main runway, the pilot had taken a wrong turn onto a taxiway, effectively. And you can see the various signs on the ground saying what should happen. And I think it didn't go to trial, actually, John, did it?
No, it did not. And yeah, part of, as you can see now, he'll be going on a dark runway.
Half the length to go down.
Yes, you only have half the length, and part of, I mean, the transcript part of the recording was, why is it so dark over here? So unfortunately, yes.
And this is animation,
This is animation, correct.
not cheap, as I recall.
No, and you know,
You see it there.
there you see it there. Correct, yeah.
I've always thought one of the most dramatic pieces of animation I've ever seen, and actually, not many of my defendant colleagues would agree with me, but I think a judge should be able to see something like that. So, can we just talk about whether we think we get it in America or England?
Yes.
How might you deploy that? I think you've done some videos in the airlines crash, but of course that's still current.
That's still current. Unfortunately, yes, I could not bring those videos. They're similar, a little higher quality as the technology has improved. So what we did in order to put together that video is we have an expert who used to be an NTSB investigator. The NTSB is the National Transportation and Safety Board in the United States. They investigate all air crash cases. He took all of the data off of what's commonly known as the black box, so the digital flight recorder that says everything that happened in the plane, every mechanical issue. He plotted it out, worked with the animators to come up with a similar an animation similar to this, showing the movements of the plane throughout the roughly 6-minute flight prior to crashing.
And if you were to do that again today, that animation, would you simply be able to introduce it into evidence, or would you have some fights with the defendants about whether it could go in?
Well, they would. Oh, yeah. We have fights with the defendants all the time, especially with this. You might have noticed that there was no sound. One of the fights that they put up is if you put in noises of a plane's engines, of like, well, that's not that plane's engine, so you know, it's not reliable. It's non-reliable, so they'll object to it. But through the use of our experts, laying the foundation that it's based on reliable data, that's how we get it in. And this would be able to be entered into evidence as opposed to what we have as a demonstrative, which is a little different. A demonstrative is not allowed to be entered into evidence because it's only used to aid the jury's understanding. So
one thing I learned from it, and I put into practice in several cases, is actually if you do a road traffic act and you've got CCTV, if you get someone to plot accurately what the CCTV shows, so you can show where the motorcyclist was when the car turned, it can be very compelling evidence. I mean, after all things, that's something I learned from the US and from your firm in particular, actually. Peter, would you use stuff like that? Would you see it to be a problem?
No, I mean, we encounter the same challenges that John talks about, but it's very powerful. And we frequently produce these kind of animations for the purpose of assessment discussions, particularly not only in cases where there's US jurisdiction, but also others. It's
a good way, isn't it, of showing the defendants how extreme and how grievous all this was, I would think.
Yeah, and it's also a very good way to show the families what happened, because when you try and explain complex accidents, they often struggle with understanding that. You put that into an animation and actually can grasp what really went on.
Sarah, you first saw that 12 years ago. That's right. Would we have a better chance of getting it in a UK court now, or court in England and Wales, than we did then?
Yeah, I think so, probably. I mean, obviously, you've got all the usual arguments around what is opinion and what is fact, and where the borderline is between the two. But I think there is more flexibility and a bit more willingness to look at visual and demonstrative evidence than there was before.
And Peter would just like to tell us about one of these cases at the moment, which involves the helicopter crash at Leicester City, very much ongoing. Are you able to help us with how you're approaching that or how you might approach it?
Sure. So the Leicester City Football Club crash happened on 27th of October 2018. Many of you remember there was an Augusta Western AW169 which took off from Leicester City Football Club carrying the chairman. It reached about 400 foot before it lost control, spinning and crashed, and everybody on board died. The investigation into that accident is probably the longest AAIB, the English investigation equivalent to the NTSB, that I'm aware of. The report was published on the 6th of September this year, so it's nearly 5 years investigation. And it's a fascinating report. Taking a step back away from the law for a second, it's a fascinating report because it's an example of how easy it is for aviation companies to make mistakes and for those mistakes to really build through the process. So they designed this helicopter based on certain hypothetical forces that it would experience in tail rotor. They then missed an opportunity to validate that hypothesis repeatedly throughout the design process, through tests, through involving the bearing manufacturer, through looking at bearings that had failed and identifying why they failed, and through having a sufficiently robust routine inspection schedule. What ultimately happened was this one little bearing failed, and it failed because of a process called rolling contact fatigue, ultimately seized, and it caused the helicopter, effectively the control rod that links the tail rotor to the pilot's pedals where he's controlling yaw, it completely disattached those. So you not only lost the yaw control, but actually it exacerbated it because the tail rotor blades went to a full position. So what was particularly kind of, I guess, harrowing in this was that in the design process, the Leonardo, the designers, the manufacturers of the helicopter, had recognized that the failure of this particular component was catastrophic, and meaning under their definition it would result in the loss of life of people on board, and that it was a critical component. But despite that, and despite everything I've said, they didn't put in any sufficient mitigation measures, even though they had in other variants of that helicopter mitigation measures that they could have used. So with all that being said, where does that leave us on the law? Well, that's a claim that if you bring in England, it will be a claim brought under the Consumer Protection Act, potentially under negligent principles of common law. What we can do in England, which is a different position from America following the case of Rogers and Hoyle, we can use that accident investigation report, and that will form the kind of the base of the claim and the allegations of negligence. And it's only really if the parties, whether us or the defendant, disagree with elements of that investigation that you would then adduce expert evidence.
And by the sound of it, whilst we might have looked at it and seen that's a dreadful helicopter accident, that must be what happens when you have helicopters. Actually, it's a helicopter disaster, and one for which it may be possible, rather more than that, I suspect, to show there was real fault.
Yeah.
And that liability should follow.
Yeah, of course, Leonardo wouldn't agree with me, but these accident investigation reports, they set the principle that goes all the way back to when the legislation surrounding this was devised in 1944 as part of Annex 13, that the investigations are solely for the purposes of safety and not blame. But in practical reality, you can infer blame from those, and this is a report where, acting for the claimants, I think we can infer blame.
I did one inquest involving a helicopter accident, and it became clear partway through from the Ministry of Defence's counsel that actually they recognised that some liability would follow. So inquests and this and so on are extremely useful in this particular field, certainly in England and Wales. Okay, I think I've talked us out with this. I'd love to carry on. I know you all would too, but as the director would also say, I am now standing between you and the cocktail hour. So we won't keep that running too long. But can we see if there's any questions, some quick questions before we really wrap up for the day? Well, Isabel Bathurst.
May I just ask, Tom, at the outset you mentioned the knowledge of the airline in relation to the fact that they knew that there was a defective issue at the outset. How did you establish that, and how much weight was attached to that?
Yeah, it was the airplane manufacturers. It was Boeing. It wasn't the airline. We established that. Well, there was a lot of hearings, government hearings in the United States too, where they did a lot of the digging and a lot of the discovery that we eventually got access to, and it's so confidential, but we got access to Boeing communications and emails. And I'm not at liberty to discuss those emails, but we found that the government investigation was pretty accurate in what they found concerning Boeing's knowledge. Yes.
And I can see we put a slide up there, which is just a slide showing.
Oh, yes.
And my guess is that
So this is a slide that may or may not be from our current animation dealing with Ethiopian Airlines crash.
Hypothetically, yeah.
But you can see it's a higher quality, and we have a little more information for the jury to digest in terms of, the time to impact. And here it's the G's, the G forces. G forces are, I don't want to get too much into it, but basically we were all at 1G. Anything over 1G, you start weighing more. Anything under 1G going towards 0 is like being in space and you weigh less. So this is kind of trying to get that all encapsulated. It's complex. I'm not a rocket scientist like certain people at this panel may be, but
I'm okay.
so this is to help aid a better understanding of all the complex factors. Sorry.
Well, I hope that's been of interest to you all. I've enjoyed presenting it. I've very much enjoyed conducting this conversation. And I say again, thank you so much to everyone, not just for attending, thank you each of you, but thanks to all our speakers. I think it shows the work that Ian and Sarah have been doing. I suppose mine goes back a little further, but recently they've built just a terrific network up. And we have some of our great UK friends here as well. It's been a pleasure. John, Peter, Sarah, thank you so much for helping.
Thank you, Joe.